Hello friends, welcome back to Signature Law Firm. Our today's guest is Mr. Bharatkumar Modi. He is the GM of Kalpataru Transmission Limited. He will share his knowledge about the Contract Labour Regulations and Abolitions Act 1970.
Modi, I am working as a General Manager, Legal and Corporate Sub in Kalpataru Power Transmission Limited. My main responsibility in Kalpataru is the industrial relations. We have more than 5,000 people in all over the India and around 1,500 people in our Gandhinagar plants. Today I am talking about the industrial relations and industrial law. In each and every organizations, there are finance departments, there are marketing departments, and other departments are there. Like that, the HRs and the IR. HR is also very important department, but IR is not less important than the HR. Now I am talking about the industrial relations. Industrial relation is governed by the various industrial law. There are Industrial Dispute Act, Factories Act, Contract Labour Act, and for the welfare of the benefits of the organizations and the workmen and the staff, that the Social Security Act is also there. That is called Provident Funds, Employee State Insurance, payment of bonus, payment of gratuity, etc. To govern all these things, there is a Model Standing Order Act. In this Model Standing Order Act, they talk about how the people has to behave, how they have to act in the organization, how disciplines to be maintained. These are the all requirements are made in the Industrial Standing Order Act. Now basically, in all over the India, the main focus in the organizations where employing 100 or 200 or 1,000 or 5,000 or any PSU or any government enterprises, they are bothered about the Contract Labour System Act, which is a very, very core act and core subject in the industrial law. Today I will explain you in a very few lines and very clear-cut message what is the Contract Labour Act. This is called Contract Labour Regulation and Abolition Act 1972. This act says about the two things. It's a regulation and the abolitions. Now where is the question arises, the regulations of the contract labour. If the organizations employing the contract labour through the contractors, but when the industrial courts feels that the labours employed by the contractors, if the contract system is total sham and bogus. Now the question is there when the sham and bogus contract can be established. Number one, if there is a contractor has not been appointed properly, he is not supervising properly his man. So that is the question: who is the supervising their workers? Who is passing their leaves? Who is sanctioning their loans? Who is paying their own benefits? These are the areas where the courts can determine whether the labourers are working as a principal employer or the contract labourers. Now what to be taken? As a wise man, as a wise organizations, we have to take the care that in our organization, the contractor is an independent entity. Now the contractor has to take his registration under the Contract Labour Act and has to take the labour license. Whereas the principal employer has to take the registration as a principal employer. So the contractor has to appoint his own men to supervise his own labours. They have to design the works, they have to designate their work, then they can take their day-to-day attendance, their provident fund calculation, their wages calculations, their leave calculation, their leave approvals, everything to be taken care by the principal contract labourers. The principal employer persons, authorized persons, should be only present on the day when the salary is disbursed to his labourers. That is the only responsibility, basic. Then what else? If the contractors has to take the care and there is a job descriptions, suppose in the organizations, the principal having his own workmen, that the workmen's own workmen's job descriptions and the contractor labor job description should be differs. This should not be matching. The nature of the duty should not be a perennial. It should be a seasonal. Now, what are the basic responsibility of the contractor and what are the basic responsibility of the principal employer? That is established in the law. The basic responsibility of the principal employer is he has to take care of the registrations under the principal employer as under the Contract Labour Act. Number one. Number two, he has to ensure that the contract labour provident fund and employee state insurance company should be regularized depositing in the respective government authorities. Number three, the principal has to take care of the welfare facilities, what are the framed under the Factories Act, that is to be taken care of the contract labour. Number five, there are the safety measures under chapter 4 of the Factories Act. The safety measure is there. that is to be taken care by the principal employer. These are the responsibility of the principal employer laid down in the law. Now, what is the contractor labor? Number one, he has to take the labor license under the Contract Labor Act. Number two, he has to pay the bonus time to time whenever he has completed the 5 years of this job and business. He has to pay the bonus. Number three, he has to pay the gratuity. If workman completing the 5 years of services, he has to pay the gratuity. Number five, he has to see that his persons and workers should be get the proper designated and proper safety measurement. These are the principal employers and these are the contractor labor's responsibilities. Now, whether if the principal employer is depositing a provident fund, yes, on behalf of the contractor, whether it is a contractor laborers or principal employer, no, there is no. If neither major question and frequent question is there, if the industrial courts decide that the contract system is sham and bogus, then what is the problem and what is the remedy? In that case, when the industrial court decide the contract labor is totally sham and bogus, in that case, the principal has to appoint and has to regularize these permanent laborers as a permanent labor of the contract labor. Whereas, if the contract labor is abolished, in that case, it is not mandatory that the contractor labor should be absorbed by the principal employer. These are the words. Now we are talking the major issues of the Contract Labor Act. I told you earlier the Contract Labor Act regulation and abolition. Now I am talking about the abolition. Who can abolish the contract? Now, when there is any complaint, why the complaint is given? The unions and others are giving the complaint, government officials. When in the organization, some people, 20% people in the 1,000 out of 1,000, 200 people are working as a parallel job and 800 also doing same job. And whatever they are doing is a parallel job. In that case, the government can appoint a board and board can conclude, board can go through all the details, whether the nature of the duties what performing by the contract labor is a parallel nature, if yes. Number two, whether the working facilities and safety and health, everything is in line with the thing. Number three, what are the disciplines, measure taken, action taken by the principal employer or the contractors. Number four, whether the control of the contract labor is the principal employer or by the contract labor. These are the factors. In these factors, this board can come to the conclusion that the contract labor should be abolished. They have to submit the report to the appropriate government. Now, who is the appropriate government? In that case, when the unit is, when the factory is in the state government, it is controlled by the direct any private limited, public limited company. In that case, the state government is appropriate. When there is a government, the PUC, then there is any organization which is run by the government, it is appropriate government is a state government. But where is a PUC, like a Power Grid Corporation of India, in Indian Oil, like that, these organizations is controlled by the government, central government. That is why their appropriate government is the central government. They submit the report to the central government. Then central government will call the union representative, organization representative, and the board representative. Then they determine whether the contract labor should be abolished or not. After that, they declare in the newspapers and they issue the notification. These are the basic main provisions of the Contract Labor Act. Now, what are the facilities to be provided to the contract labor? These are the as per the provisions of the Factories Act 1948. What is that? When the contract labor is more than 250, the management has to provide the canteen. When it is more than 150, the proper sitting arrangement and proper lunch facility, lunch room should be there. When more than 50 female laborers are there, in that case, restroom is to be provided. And other facilities, washing facilities, drinking water, their urinals, their latrines, it should be as per the provisions of the Factories Act. These are the basic things to be provided under the Factories Act and this Contract Labor Act. Now,
thank you, Mr. Bharatbhai Modi, for your valuable time and knowledge. And guys, if you like the video, please like, share and subscribe. And yes, stay tuned for more information about the laws. Thank you.